I, in the beginning, express my deep reverence to the greatest teacher of this world, of my Lord Buddha, Gautam Buddha. I also express my deep respect to the architect of Indian Constitution, Dr. B.R. Ambedkar, for his dedicated, incomparable work. I bow down my head for the outstanding work done by the revolutionary, great reformer, Jyotiba Phule, Chhatrapati Shahu Maharaj. Today, before I forget, I welcome you all the dignitaries, all the learned, and all our guest of honor, my friend Advocate Khobragade. Today we gather here for the most haunted question: can the law, which has become a modern scripture, is sufficient to oppress the caste system, or to eradicate the caste system, or to prevent the caste system? We have discussed elaborately all the issues here. I remember Dr. Baba Sahib's words that the political democracy will last only when at the base of it there is a social democracy. So what I have gathered up till now from the learned speakers' speeches, that there are horrendous incidents, history of caste atrocity. Some incident which I must quote here, that sir, the revolutionary movement, as per our knowledge, has begun with the Madras in the matter of untouchability, and that was a first case somewhere in the year 1931, a case titled as Shankaranand versus Dorai Swami. It was a case relating to entry into the religious temple, if Mr. Lakshman recalled it. And a civil suit was filed against untouchables, that they cannot enter into the temple. They don't have a right to worship. This was agitated by the untouchables. Very fierce battle was gone there. And ultimately the suit was decreed in favor of the upper caste people. The matter was challenged in a superior court, that is ADJ court. There also the lower court's order was confirmed, and at that time there was no Supreme Court, but it was a Privy Council which was situated in London. So these Madras untouchable peoples went to the Privy Council, but there also they lose it. Question is not of their losing, but it is about the fighting spirit of the Madras people. What we require today is that spirit to fight against the odds. What we require, the basic knowledge of law. We need to have a complete knowledge of law. We are not expert. But what we require is the line of action. And the line of action begins in the matter of atrocity by registering a case, by filing a complaint, which is not done by the literate class of people. Unless they face some kind of atrocity. What is expected from a victim? That he should go to the police station, lodge a report, make a concise statement of his incident, and the police machinery is set into the motion. This is expected. But what happens in the matter of atrocity, that whenever a victim approaches to the police, the first of all, he is not welcome in a proper manner. He is shunted away many a times, assaulted by police. There are incidents. I must not quote because lot of incidents have been quoted. I am on the point of line of action, what to be done, what should be the way out of it. So there are some changes in law. Earlier the law was not sufficient. 1955, from 1955 to 1989, 89, 95, amendments are there. 1916 amendment, the latest amendment is very important in a sense that Dr. Babasaheb Ambedkar, during the formation of the Constitution, included fundamental rights under Article 30, but make an effort to go with this provision, and therefore there are less number of atrocity conviction. For this purpose, we should blame ourselves. There are incidents, because atrocity is such a thing which is in the mind, and it takes time to improvise the mind, the structure of society. It is a difficult task. Our society is manned by political person. They create narrative which becomes a practice, that becomes a custom, and that customs are becoming hurdles in the matter of atrocity. So it is the duty of everyone literate here or in the society of a literate person amongst the atrocity, amongst the untouchables, that they should come with such new ideas to minimize the feeling of hatredness, to inculcate the spirit of brotherhood, fraternity, and to teach Dhamma. Dhamma is based on Maitreya. That is the need of the time that we can do. That is the least possible thing a common man can do if he is not even a victim of atrocity. This is a need of time, and there is now a very important provision in the Atrocity Act for a victim, and it has given so many powers. You will be astonished to see that under section 15A, you just imagine what power should have been there in the atrocity for a person for a victim, and that power is included here. That facility is provided. You imagine some facility where there is a right to education. Yes, there is a right to education. You imagine anything in your mind, and that remedy is provided under section 15A. You do not have to file a petition in High Court or Supreme Court for the basic human rights. So, with your permission and with the permission of the dignitaries on dais, I will read the provisions because they are more in number. Because of this section, the judiciary is very much afraid of dealing with the cases. Rights of victim and witnesses under chapter 4A. Rights of victim under 15A. It shall be the duty and responsibility of the state to make arrangements for the protection of victim, their dependents and witnesses against any kind of intimidation or coercion or inducement or violence or threats of violence. You understand the meaning of it? The protection is from the state, not only to the victim but dependents and the witnesses as well. Then the victim shall be treated with fairness, respect, dignity, with due regard to any special need that arises because of victim's age, gender, or educational disadvantage or poverty. Here, whatever relief available should be provided to maintain the dignity of that victim. Then, a victim or his dependent shall have the right to reasonable, accurate and timely notice of any court proceeding, including any bail proceeding, and special public prosecutor or the state government shall inform the victim about any proceeding under this act. So it has been practiced in Maharashtra. I don't know about the Madras, Tamil Nadu, but in Maharashtra it is very well practiced that notice is given with regard to every stage in the proceeding to the victim. Even if the accused are brought for a police custody remand or magistrate custody remand, the notice is given to the victim. And after hearing the victim, then the proceeding starts, further proceeding starts. So it is a very important and powerful tool given to a victim. A victim has or his dependent shall be entitled to be heard in any proceeding under this act in respect of bail, discharge, release, parole, conviction or sentence of an accused or any connected proceedings or arguments, and file written submission on conviction, acquittal or sentencing. Then there is another provision of 15A6 which says that complete protection to secure the ends of justice. This is one line which covers everything. Complete protection. Now you imagine what kind of protection you want. If you want vehicle, the vehicle will be provided. If you want medical aid, then medical aid will be provided. All kinds of protections are to be secured. For what purpose? So that the victim should get the justice. This provision is there. You are also aware of it. Then the travelling and maintenance expenses during the investigation, inquiry and trial. He do not have to spend money from his pocket. Here the travelling and maintenance expenses during investigation, inquiry and trial is provided by the state, and it is duty of the state machinery. Social economic rehabilitation during investigation, inquiry and trial. The socio-economic rehabilitation, this word connotes a very deeper meaning. Rehabilitation means if you are dispossessed from your house, if your house is burned, if your house is demolished, then it is the duty of the state not only to rehabilitate him, but economically they have to support him for his livelihood, or to provide a job, or to shift him on such location where he will live a dignified life. This important provision is there. What I am reading is the beginning of the protection. There are many provisions. Then the state shall inform concerned special court exclusive special court about the protection provided to any victim or his dependent, informant or witness, and such court shall periodically review the protection being offered and pass appropriate orders. So if protection is not given, if the facility is not provided to the victim, it is the duty of the court to review whether the benefits are provided to the victim or not. It is the duty of that trial court, that is a special court. Now here I will stop and explain what is the meaning of special court. Special court means a special, which is defined in the act, but it is a special act and it has been constituted for a special purpose. And therefore there is a special law. And this special court means exclusive. Exclusive means only dealing with the cases of atrocity. But unfortunately, in our Maharashtra or elsewhere in the India also, there are no such exclusive special court. Atrocity cases are tried by session court, but they are not exclusive session court. The additional work is given to the additional session court or even to the ad hoc court, which I have realized in my 25 years of practice, that I did not find any exclusive special court for atrocity. We need to have work on it to make representation to the authorities that in the matter of atrocity only, exclusive special court has to be constituted as per the provision of this act. So it is the duty of the social worker, reformers, the NGOs, the whistleblowers to make such representation to the government, and the government will take the necessary care. And it is all the representation has to be made not only to the government but the department, the concerned department, that is Law and Judiciary Department. And ultimately, one copy of it should be provided to the Chief Justice of India. He is the proper person who can create such special and exclusive court, which is yet not created. And this is one reason that some hurdles are coming in the matter of trial in the atrocity. Then there is a subclause 7 that states shall inform the concerned special court or the exclusive special court about the protection provided to any victim or his dependent, informant, witness, and such court shall periodically review the protection. Then 8, without prejudice to the generality of the provision, there are certain protection given, that is concealing the names and address of the witnesses. This is only happen in the matters of in a sensitive matters like rape, POSCO Act, prevention of offences under the Sexual Offence Act and to the children's. Therefore, such provision is there. This provision is also provided in the Atrocity Act, that concealing the names and address of the witnesses in orders, judgments, or in records. So the purpose is that the victim should not be defamed in the eyes of the people of the society. The issue, direction of or non-disclosure of the identity and address of the eyewitness. Take immediate action in respect of any complaint relating to harassment or victim, informant or witness on the same day. If necessary, pass appropriate order for the protection. This is also very, very important. You just think about, you name the right, and that is incorporated in this section. It is a small section 15A, but it covers all the acts, all the protection which is there in the Constitution. I said rather than more than the Constitution. It covers the natural rights, human rights, and civil rights as well. It shall be the duty of the investigation officer and the station house officer to record the complaint, victim, informant, witness against any of the intimidation, coercion, inducement, violence, threats, violence, whether given orally or in writing, and a photocopy of the first information report shall be immediately given, free of cost. All proceedings relating to offence under this Act shall be video recorded Now this is very much important. Sir, you talk about the social media. Here, the what is your mind is already incorporated in the act. Why video recorded? Because to see that the judge, the administrative officer of the court, the councils are working free in a fair and a transparent manner to meet the ends of justice. So this is a very important problem. Whenever we used to make an application, even in the bail matter, sir, if we tender an application under this provision to get video recorded our proceeding, the judge gets very much tension and he rejects the bail in a bail matters. If many judges get afraid of and they try to prolong the litigation, they don't want to get their trial to be video recorded. Because what I said, that atrocity cases are because there are hatredness in the mind. It lies in the mind of the person. Judges are no exception. Politicians are no exception. All the dignitaries are no exception. All the good peoples are no exception. Because it was a custom earlier, that customs will not get eradicated all of a sudden just because there is a law. There is a need of need to do some sensitization work. There is need to do work on awareness. The need to teach what is equality means. There is a need of giving true interpretation of the constitutional provisions with regard to the gender bias, the sex, the birth. All are. This is all because bad things, bad notions are being carried out in the mind, and this is the root cause of the atrocity. So there are other provisions also which I will read rapidly if I am not boring you. But this is very important because even the judges are not aware about the latest development of the act to provide immediate relief in cash or in kind to the atrocity victim or the defendants. You see, a poor person goes to the police station and he do not have penny. Most of the victims are laborers. They don't have penny to even to travel and to make necessary arrangement to lodge a complaint, because police station is situated at Tahsil place, and mostly the victim atrocities are committed at rural area. Most of the atrocities, because police protection is not easily available there in a rural area. So this provision is made to immediately provide him relief in cash or in kind. Atrocity victims, kind means they have to give him good treatment. The police jeep can be provided for traveling, for sending the victim to his own village, to provide relief in respect of death, injury and damage to the property. Now these reliefs are there are schedule. In that schedule, the reliefs are there as per the nature of offence. If death is committed, then there is a relief of providing lakhs of rupees. When it go, to my knowledge, it is 8.50 lakhs immediately has to be provided to the family of the victim where the death is caused. So huge amount of money is there to make them financially stable and to come out of their problems of poverty, to arrange food, water, clothing or shelter or medical aid or transport facility or daily allowances to the victim. What more you require? Food, water and shelter also, even clothes are also provided. To provide maintenance expenses to the atrocity victim and their dependents. The right which is given under 127 of CRPC, now corresponding to the provisions of BNS Act 2023. The maintenance, there is this maintenance provisions is, there are so many provisions for the maintenance of senior citizens as well as to the wife. This maintenance right is provided here in the atrocity. Once you lodge the complaint and become the victim or you come under the definition of victim, all these provisions are applicable to you, and all this you are entitled for these benefits. To provide information about the right of atrocity victim at the time of making complaints and registering the offence. So it is the duty of the state to show that all these rights are available to you. You tell us what you want. You just name it. What are your problems at present after the commission of the atrocities. To provide protection to the victims and their dependents and witness from intimidation and harassment. To provide the information to the atrocity victims or their dependents or associated organizers individually on the status of investigation, charge sheet, or to provide copy of a charge sheet free of cost. Earlier there was a free of cost delivery of FIR. Now charge sheet is also required to be delivered free of cost because it is a huge compilation. To take necessary precaution at the time of medical examination. To provide information to the atrocity victim or their dependents, associated organization, individuals regarding the relief amount. So even if an illiterate person becomes the victim of the atrocity and lodge a complaint to the police and case is registered, he is entitled to be supported, guided by the organization, his representative, or from his dependents. Then to provide information to atrocity victims or their dependents or associate organization individuals in advance about the dated and place of investigation and trial. To give adequate briefing of the case, preparation of trial. To execute rights atrocity victim of their dependents and associate organization. It shall be the right of the atrocity victim of their dependent to take assistance from the non-government organizations, social workers and advocates. The advocates comes under the last category here. But now a question which arose to my mind, what more facilities required to be given to the victim of atrocities? Is it not that your fundamental rights are being guided, protected without any filing, without you file any petition in this Supreme Court under the writ of habeas corpus, mandamus, certiorari? All these rights are incorporated. But these rights are not known to the victims, also not known to the judges, also not known to the advocates also. So there are those judges practicing, advocates practicing in this field are not making the appropriate applications in the court of law so that the benefits of section 15A should be given to the victims of atrocity. Thing is that law always comes, law always keeps changing, and it is, in the words of Dr. Babasaheb Ambedkar, there are many provisions, but I think I have taken enough of your time. Sometimes I will come with the PPT presentation along with Mr. Mangesh Daivale. With his guidance, I am working on it. Even some advocates and social workers from Madras, they have done a very good compilation on the atrocity that I will be exhibiting in my further, if I get an opportunity. Today I could not prepare it because it was a working day for me. Today I attended 4 courts, CAT, MAT, High Court, and the proceedings before even the National Commission was there, and we got relief in 2 cases with respect to service matter. Now those who are in service, they don't feel that the Atrocity Act is for them. Today we got an order from the National Commission which was there in the Ravi Bhavan today. It was being conducted, and there we in one case we said that the promotion rights are withheld. The promotion opportunity is withheld of our client, and vexatious departmental inquiry is initiated. So that we file a complaint under the Atrocity Act under 31 PQ, and relief was granted to him today, and investigation is also ordered, and that too by the decision was to be taken by the Deputy Director of Education. It is a case related to the municipal corporation teacher who was deprived of his promotional post. Before I conclude, I again remember the words of Dr. Babasaheb Ambedkar. Baba Sahib Ambedkar once said that if your right to dignity is, I have the water. If your right to dignity or your right to self-respect is taken away, then you should change the system. Today, I appeal to all of you to make such change. The change can be in the program, the change can be in the courtroom, the change can be in the society, and there will be a change in the mind. Therefore, we will achieve the target what we said today, that is Bahishkrit Bharat to Prabuddha Bharat, from oppressed Bharat to enlightenment Bharat. Thank you. Jai Hind.